Ready, Courtney?
Yes.
All right, it's 9:11 a.m. on June 16, 2016. We're commencing the Tennessee Board of Court Reporting meeting at the Davy Crockett Tower in Nashville, Tennessee. We have the agenda before us, but first of all, we'll have a roll call. Ken Mansfield,
John Rambo.
Ken Gibson.
Britton Collins.
Okay, we have a quorum established. We have the notice of meeting with the agenda. Do we have a motion to accept the agenda?
I make that motion.
Okay, we have a motion. Do we have a second?
Second.
We have a motion and a second. All in favor, say aye.
Aye.
Aye. Any
Aye.
opposed? No opposed. Unanimous. All right, we have to review the minutes from November 20, 2015. Has everyone had an opportunity to review the minutes from November the 20th?
Yes.
Yes.
Any discussion, any changes or deletions that we need to discuss?
I think they look appropriate, and I move that we accept the minutes.
Okay, that's in a form of a motion.
Correct.
Okay, do we have a second?
Second.
All right, all in favor, say aye.
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 All opposed? It's unanimously passed. The minutes are approved. We do have to do a roll call votes for all these, so we'll go back even to the agenda. We had a motion and a second. Ken Mansfield votes aye.
John Rambo, yes.
Ken Gibson, yes.
Britton Collins, yes.
Now back to the minutes. We already have the motion and a second. I vote aye.
John Rambo again, yes.
Ken Gibson, yes.
Britton Collins, yes.
So they have moved on. Next thing on the agenda for today is the director's report. Nicole.
Thank you, sir. Let me turn to that item on the agenda. If you look on the director's report in your iPads, which is on page 6, I have for your review the budget information. At the top is the last year's financial information for fiscal year 2014-15 and the current year's estimation for 2015-16. Budget plan is $57,500. Total expenditures thus far this year is $4,267.30. Total revenue generated is $7,475 as of April 30th. The estimated cost backs is $9,017.93. And of course, we actually have received a lot more revenue in this last month here in June because all of the court reporters are renewing this month. So we are set to make a great deal more revenue in this last month. And we've had a huge upsurge. So we are anxiously awaiting to see what those figures will be here. For a legislative update,
Before we go to legislative updates,
sorry.
is there a breakdown somewhere we can look at for the total expenditures rather than?
I did not bring that with me. It wouldn't be very
Okay.
specific. Doesn't have any information that would be exceptionally relevant. It really just has salary allocations.
Salaries.
Yeah.
And it doesn't designate whether it's for legal salaries or it's just salaries for staff here.
It's really just a breakdown of my staff salaries. Yeah.
Okay. Okay,
The cost backs will have the legal staff salaries.
okay. I was wondering about the cost backs too.
Okay.
Sorry for the interruption.
No problem at all. But it'll break it down more once we get to June 30th.
Right.
So really at this point, there's not a lot of information that would be useful to the board. Next meeting, I'll give you a more detailed breakdown because that's when it's really going to show.
Right.
It's going to have more information to the commission or to the board.
Speaking of that, do you have an anticipated date for the next meeting? Sorry about that.
I do. Um, After we do the next part of the meeting, I'll tell you that because
Okay.
I'm just gonna have to look that up.
Okay,
Okay.
thank you.
This is the next part is the legislative update. It's the Right to Earn a Living Act is Senate Bill 2469, House Bill 2201. It was called the Right to Earn a Living Act. This bill that requires all agencies review any entry laws and regulations each year and repeal or amend those that are determined not to be demonstrably necessary and carefully tailored to fulfill legitimate public health, safety, or welfare objectives, or in the case of laws, recommend the General Assembly that the law be repealed or amended. Additionally, a person may petition an agency to review an entry regulation, which must be reviewed within 90 days in order for the agency to repeal or modify the regulation, or state the or state the basis that the regulation meets the standard. The agency's decision on the petition can be challenged in court. On May 5th, 2016, that public act became, or that, excuse me, that Senate bill became Public Chapter 1053. Legislative session is complete for this year, and now we need you to consider if there's any legislative proposals for next year. Please remember the administration's agenda planning process includes consideration of agency proposals, executive department research into the policies, priorities set by the governor, and development of strategies to address significant issues that legislators and/or interest groups are likely to bring forward next year. The governor makes decisions about what is or is not included in the administration's agenda based on this full picture of everything that will have to be balanced in our next session. The department evaluates proposals based in part on the following criteria. Does the proposal align with the governor's vision for the state? Does it help advance his priorities or make improvements in those areas? Is it good public policy? How does the proposal affect or interact with the suggested bills from the agencies? Does it cost the taxpayer money or is there a fiscal impact? Is a change in law necessary to achieve the desired outcome? Understanding that the administration will continue to put forward a legislative agenda that contains a limited number of bills, we expect that any proposed will reflect the highest priorities of the commissioner and the governor. When thinking about 2017 legislative proposals for court reporters, please keep in mind the legislative proposals should generally reflect one of the governor's priorities: education, jobs, efficient and effective government. Also consider whether or not the intended outcome of the proposal could be accomplished by rule. At this point, I'll turn it over for discussion.
Question?
I would just like to ask a question. So a rule can be, so that last sentence, also consider whether or not the intended outcome of the proposal could be accomplished by rule. So it's preferred to have a rule change rather than a legislative action.
If you have legislative authority to accomplish something already by rule, then it would be better to do it by rule. If you don't have the authority to do something, though, you can't do it, then you would have to get legislative authority and then do it.
So you can't
You can't,
use a rule to enforce a law that doesn't exist.
right, you can't create a power by rule.
Right. Any other discussion?
None from me.
None for me either. Anyone? licensing update.
Okay. The licensing counts are there on the iPad for your review. That was as of June 6th. The numbers have modestly changed recently, but it's a pretty good reflection of where the licensing numbers are. We've had a few court reporters renew since then.
Do you think the number will go up from the 529, or do you anticipate it might go down?
I think it'll probably go up just a little bit, but it's basically those are about what the licensing numbers are holding at.
So it looks like we're about 120 plus or minus so down from what we were initially a few years back,
Yes,
which may be an indication of the signs of the time somewhat,
yes.
amongst other things. I have a letter from the National Verbatim Reporters Association.
Correct, and this is something you probably should consider. Originally, Jimmy Jane McConnell had requested to attend this conference, but given that she's received her letter from the governor, maybe someone else should consider this. She had requested to attend the National Verbatim Reporters Association annual National Alliance of the State Associations meeting in Greenville, South Carolina on July 21st. Or I guess the convention is July 20th through 23rd. I'm not sure what date she had originally attended to participate in, but I know she wanted to at least be there the 21st. I'll just turn it over for you guys to discuss if you wish to send a board member to this or not, or if you think staff should go or whatever. I'll just turn it over for discussion.
Well, Jimmy Jane's replacement should be, according to the law, either a voice writer or an electronic writer. If it indeed is a voice writer, I would say that we would need to make a motion and see if that person is willing to go to this meeting as a member of the board. But I don't know who it is.
Yeah, do we even know if she's going to have a replacement in place by that time?
I don't know. See, it's all up in the air. It's all speculation at this point because I don't know if someone's been appointed. I would assume someone has received an appointment when someone has received a letter thanking them for their service, but I don't know that to be the fact. Do you know, Nicole?
I don't know, not at this point, really.
So we're at a standstill as far as this goes for this meeting. At this juncture, it looks like we'll just have to table this request if and when someone comes forward who's a voice writer who could attend. Of course, the way I understand, the National Verbatim Reporters Association is also open to steno reporters as well. So if someone on the board wanted to go as a steno reporter, I think they would be welcome as well. That's my understanding. We had made a discussion last year that I was possibly going to go, that it wasn't feasible for me to go, but we had voted that I could go if I chose to. I don't know at this juncture. I don't plan to go this year. Ken, do you plan to go?
No.
I don't know if we have anyone who's planning to go. Of course, Jimmy Jane is out of the question at this juncture. It looks to me like we'll have to table this, and if we don't meet in July before it, it's just kind of a moot point for this year.
I agree, Ken.
What are the specific criteria on who can and cannot go?
I would assume they probably prefer a person who's a member of the NVRA. It's mainly a voice writing organization, but I know that they do have some steno membership as well. But I'm assuming that they would prefer to have someone who's a member of their organization be in attendance, and they really want someone on a state board or a state association as well. But at this juncture, we don't have anyone that we could authorize to send. I think we'll just have to table this, and if we have a meeting before the meeting, perhaps we can discuss it then and bring it back up. But I think we should table it for now.
I agree with your course of action, Ken.
Discussion?
All right. That concludes the director's report.
Legal report?
This board meeting, we actually do not have any open complaints, so there
Okay.
is not a legal report to present to the board.
That is good news in and of
Always.
itself. That's always really good news. Well, I suppose at this juncture then, we're ready to go right into the rulemaking hearing.
I'm sorry to interrupt, but we'd had that one complaint that had been open for a long time, and we'd gone back and forth about potential consent resolution. Did that ultimately get resolved, or are y'all still trying to work that one out?
I apologize, Mr. Collins. Yes, that was signed and entered February 12th, 2016, I believe was the date that it was signed.
Okay,
did-
great.
Colin, we did receive a consent order on that, and it was signed by all parties. If it's the one I'm thinking of. And Ashley's nodding her head that it is.
Okay.
We need to take a break or go right into the rulemaking hearing?
I think we're all good.
Okay. So let's go right into the rulemaking hearing then. Again, this is June 16, 2016. The time is now 9:27 a.m. and we're opening the rulemaking hearing. I assume everyone has had an opportunity to review the rules. And do we have any comments from the public? Any concerns or comments or suggestions?
If I may, Mr. Chairman, there are a couple things that I probably need to read into the record before we take public comments. Okay. As you stated, it is Thursday, June 16th, 2016. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated, Section 45204, in Room 1B of the Davy Crockett Tower, 500 James Robinson Parkway, Nashville, Tennessee. The purpose of this rulemaking hearing is to solicit comments on proposed rules that the Board of Court Reporting has made public in order to do the following things: amend all references from Administrative Office of the Courts to the Board of Court Reporting, amend the rules to reflect the administrative duties as implemented by the Department of Commerce and Insurance, adjust the license renewal and reinstatement fees, remove references to expired grandfathering provisions, provide regulation for licensure of military applicants, amends the standards of professional conduct that exceed the authority of the board, amends the civil penalty amount to be assessed by the board, and it also will clarify the continuing education requirements. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State, notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for a review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, the end of which time will be the effective date of the rules. Those members of the public wishing to speak should sign up at the table at the front of the room. Only those who have signed in will be permitted to speak. The notice of rulemaking hearing included the entire text of the proposed rules and was published on the Tennessee Administrative Register website on April 26, 2016. And I would ask that the notice of rulemaking hearing be marked as Exhibit 1. Ms. Avers, if I can ask you, what additional notice was given to the affected individuals or groups aside from the notice of rulemaking hearing?
Notice was posted on our website for the rulemaking hearing.
As the agency hears public comments on the proposed rules, I, as the moderator, reserve the right to limit such comments if they become repetitive, so I just ask that you limit your comments accordingly. At this time, I'm going to briefly summarize the substance of the proposed rules for the record. Rule 0455-01-01-.04 changes reference from Administrative Office of the Courts to the Board of Court Reporting. Rule 0455-01-01-.05, again changes reference from Administrative Office of the Courts to the Board of Court Reporting and introduces the procedure related to obtaining public records. Rule 0455-01-02-.03 is amended by amending paragraph 1 and deleting paragraph 2 to read as follows. Verification of licensure will be available through the board's website. Rule 0455-01-02-.04 is amended by changing the late renewal fee to $20 per month up to 6 months and reduces the reinstatement fee to $350. Paragraph 7 that was related to the proration of the license fees is removed. Rules 0455-01-03-.01, .02, .03, and .04 are removed in their entirety based on their expiration. Rule 0455-01-03-.01 is substituted to read, any person who provides to the board satisfactory proof of graduation from a court reporting program or its equivalent shall, upon application to the board on forms approved by the board and payment of a fee in an amount determined by the board, be issued a temporary license to practice as a court reporter. This temporary license shall expire 60 days following the date upon which the next board-approved examination for licensure is given. Up to 3 additional temporary licenses may be granted upon sufficient proof of good cause for issuance. Rule 0455-01-03-.02 substitutes the language of the same rule, subpart .06. Rule 0455-01-03-.03 being the renewal regulation reads as follows. Subpart 1, a newly issued court reporter license in Tennessee shall be valid for 2 years or for other such period of time authorized by statute. The holder of the license may renew such license during the 60 days preceding the expiration date thereof by paying the required fee and completing the application for renewal. Subpart 2 is the responsibility of each licensee to notify the board of any change of address within 30 days. Failure to receive a renewal form from the board shall not constitute an excuse for failure to renew licensure. Subpart 3, late renewal applications may be received following expiration of license with the required fees. No late renewal will be granted if a completed application is not received by the board within 6 months of the expiration of the license. After 6 months following the expiration of the license, the applicant must apply for a new license. Rule 0455-01-03-.04, entitled Military Applicants, creates a procedure for the board to approve a temporary licensure to certain qualifying military members and their spouses. This rule is required pursuant to Tennessee Code Annotated 4-3-1304. This rule allows the board to provide licensure to military spouses or members who have a similar license with substantially similar licensure requirements from another state. This rule also allows military members nearing retirement to obtain a temporary permit if they performed a similar profession in the military. This rule allows for deployed members of the National Guard to allow their license to expire while deployed and obtain relicensure upon return while excusing any late fees or charges. There were some changes to the standards of professional conduct being Rule 0455-01-04-.01. There was a change to paragraph 1C, which now reads, shall provide information regarding services to be rendered regarding administration of professional services to all parties and shall make timely delivery of transcripts. Paragraph 1E now reads, should immediately seek inactive status and refrain from practice if they become impaired and unable to function according to the standards of practice. Paragraph 1K reads, shall inform the board of court reporting if they have knowledge that another court reporter has committed a violation of these standards of professional conduct or the Tennessee Court Reporter Act of 2009 that raises a substantial question as to that court reporter's honesty, trustworthiness, fitness as a court reporter. Paragraph 1L is introduced and reads, shall cooperate with any investigation resulting from a complaint or for disciplinary action. Paragraphs M through O are reassigned and they now read as paragraphs N through P. Paragraph 1P reads, shall refrain from giving directly or indirectly any gift, incentive, reward, or anything of value to attorneys or any other persons or entities associated with the litigation, except for items that do not exceed $25 in the aggregate per individual each year. Rule 0455-01-05-.04 reads, the board may investigate any person engaged or suspected of engaging in any business or activity regulated under the Tennessee Court Reporter Act of 2009. Subpart 2 of that same rule reads, upon receipt of any written complaint regarding any licensee or person engaged in unlicensed activity, the board shall provide a copy of the written complaint to the accused party within 5 days. Such party shall file a written answer to the complaint within 20 days upon request by the board. Rule 0455-01-05-.06 reads, the board hereby adopts reference as its rules the Uniform Administrative Procedures Act, TCA, Title IV, Chapter 5, for governing contested cases, appeals, and related proceedings. We also changed 0455-01-05-.06 to be the civil penalties. We moved that to a different section of the rules. We removed the formal disposition of contested cases. Rule 0455-01-05-.07 now reads reinstatement of a suspended or revoked license. Subpart 1, application for reinstatement shall include evidence of corrective action taken by the licensee. Such application shall be made utilizing the forms provided by the board. Subpart 2, in considering reinstatement of a revoked license, the board may evaluate factors that include but are not limited to severity of the acts that resulted in suspension or revocation of the license, conduct of the applicant subsequent to the suspension or revocation of the license, lapse of time since suspension or revocation, compliance with all reinstatement requirements stipulated by the board, rehabilitation attained by the applicant as evidenced by statements provided directly to the board from qualified individuals who have personal knowledge of the applicant, whether the applicant is in violation of any applicable statute or rule, and directly or implied representation that the person was a licensed court reporter during the period of revocation. Rule 0455-01-05-.08 was removed in its entirety, as was Rule 0455-01-05-.09, as was Rule 0455-01-05-.10. As for the continuing education requirements, being Rule 0455-01-06-.01, we corrected the abbreviation of CE. We just spelled out continuing education in that rule. We deleted the text of the rule in its entirety for Rule 0455-01-06-.05 and Rule 0455-01-06-.06 was also deleted in its entirety, and those were the waiver of the CE requirement rules that the board voted at their last board meeting exceeded the authority of the board. At this time, we'll take any comments. I know that was a lot, but they were posted prior to this meeting. If there are any comments, we'll take them now.
I have one question. Regarding verification of licensure will be available through the board's website. Is that available now? A list of the court
Can you
reporters who have license?
There is an Excel form on file right now that has the reporters listed. It's hard to find it, but it's there.
Okay.
I'm assuming that will be updated as of this month, of course. And that brings up another point too, which we'll get to in new business later, if I don't forget it.
I can discuss more of that later, but I think we should just wait for that, if it's okay.
We did receive one comment in writing,
Okay.
Ashley. Do you
Okay.
want to share that with us or summarize it?
Absolutely. There were actually a few questions. They were submitted, and I'll leave it to the board to discuss and how they want to answer that, because of course these have to be presented to the Attorney General's office before the rules are adopted. The first question Is do the proposed rules and regulations changes only apply to changes and all other areas remain? I believe the version that this person was looking at may have only had the new version and not the red line version. So my initial response is that yes, everything else remains unless you saw a red line change. The rules that were posted, I think initially, like I said, were the amended rules, but all the rules remain unless you've seen a red line change, which has also been posted.
I think that addresses that. The next question was about military applicants, and as you have eloquently stated, that's required by TCA.
It is.
So that takes care of that. Next section, if you want to address that, section 0455-01-04-
Yes, this particular question indicates that there were sections P through V that were added and approved by the board at a June 2015 meeting. If the board would like, I will read those into the record. I'm not sure if you all have had an opportunity to look at those, and then leave it to the board to discuss whether or not we want to make a change to that particular section, or have a different response for these additional standards.
If you would please read them into the record.
Absolutely. Section P says, shall not offer or provide court reporting services where payments for those services will be made contingent on the outcome of the action. If I can ask, Mr. Chairman, did you want to address each one individually, or did you want me to read all of them and then have you respond?
I would prefer that we read them all and then
Okay.
have responses that anyone wants to take with any issue.
Okay. Q reads, shall not enter into an agreement for court reporting services that restricts an attorney from using the court reporter or entity of such attorney's choosing. R, shall not enter into any contract with any insurer, self-insured entity, individual, or association wherein the court reporter agrees to pricing terms or other terms regarding court reporting costs or services at a discounted rate in exchange for exclusive or preferential treatment with respect to future court reporting needed or requested by such insurer, self-insured entity, individual, or association. S, shall not allow the format, content, or body of the original transcript to be manipulated in a manner that increases the cost of the transcript. T, shall not provide additional advocacy or litigation support services, including but not limited to trial preparation assistance, deposition summaries, and no published transcript databases. U, shall not enter into an oral or written contractual agreement for more than one case, action, or proceeding with an attorney, party to an action, insurance company, third-party administrator, or any other person or entity that has a financial interest in the case, action, or proceeding. V, shall not give any economic or other advantage to any party's representative, agent, insurer, or employee without offering it to all parties, including but not limited to failing to offer comparable services, including price or credit terms to all parties. Different credit terms may be offered based on payment experience or credit worthiness. And W says shall not base the compensation of the court reporter on the outcome of the proceedings.
This time, we'll open it up for discussion among the board members present. Anyone wants to adopt any of these, not adopt them, so forth.
I'm looking at the minutes from that meeting, and I don't see where we voted to add that language.
Alan, this is Ken. It seems to me at first blush at reading this that it attempts to maybe go above what the law allows. Some of the provisions.
I think we need, I personally need more time to, I think we should table this. I need more time to digest this.
I think I could agree with a lot of it in principle, but I'm not sure that we have the authority to do it. Oh, Ashley, what are your thoughts on that, as far as what authority we may have to have rules that maybe go beyond what the law allows?
Looking at these particular subsections, I do agree with you, Mr. Chairman, that I think some of them may exceed the authority that the board has to restrict court reporter services. I think as written subpart P may be okay, shall not offer or provide court reporting services where payments for those services will be made contingent on the outcome of the action. That may be something that the board could look over.
If we were to adopt P, then W wouldn't be needed because it's really redundant.
I would agree with that. If the board prefers the language of W, that can be substituted for P. Just looking at TCA 20-9-605, the board does have the responsibility, of course, to establish and maintain requirements for the ethical behavior of court reporters. That includes the conflict of interest, inappropriate relationships with a party or a party's attorney, and failure to honor a contract or commitment to furnish transcripts. So an argument could be made for some of these, but I think it's pushing it a little bit as far as possibly subpart R, as far as entering into a contract with the insurer, and then restricting the terms of that contract. It kind of defeats the purpose of the contract if the rule is gonna restrict it so much.
That's one that I had a little bit of concern about, and I agree with the principle behind it, but I'm not sure that the law allows us to go this far.
Yeah, and that's getting into an issue that we've battled over for the last several years, and there's legislation that addresses these situations, and I don't think that the board needs to be meddling itself in that. I know that there are some people in the court reporting community that want those contracts, and I know that there are others that don't, and I really don't think it's the board's position to be jumping in and trying to dictate which side of that is the best answer. The legislature's got a statute on the books that addresses these types of contracts and what needs to happen, and I think that we should leave it at that.
And we just had an issue come up and had an agreed order on that where the underlying law was violated, and that was resolved by board action.
Yeah, I don't think that R is appropriate.
But it goes a little bit beyond what the law allows us to do, I think. Someone could interpret that the law already says this. Someone might take issue with that.
So if I can ask, did the board have any other comment or to add to this particular section? Did we want to offer a complete response?
I would offer on subpart S, shall not allow the format, content, or body of the original transcript to be manipulated in a manner that increases the cost of the transcript. If I'm not mistaken, the underlying law says the reporter is responsible for their own production of their transcript, which, if you strictly adhere to the law, this rule would be not necessary. If a person is responsible for their own production, that should sum that up. They're responsible for it.
Well, can you, the term production, does that mean, exactly what does that mean? I think it's ambiguous, the term production, because in my personal opinion, your transcript is finished at the time you close out your digital file and you present it to be published. And when I say published, I mean given to someone to print or to distribute.
I agree with that. And then we've never defined it what production is. But you would think certainly production is not printing. Production would be the completed transcript. And if you're responsible for your own production, that means you've approved the transcript, and printing it is not a part of that, as I understand it. But if you have approved the transcript and it's in a lockable format, it could not be manipulated. But this just merely says that, I know, for example, a PDF cannot be manipulated, but an ASCII perhaps could. But if it's in a printable form, such as a PDF, I think that would be in adherence with the law. But if it's presented in a form that could be manipulated, I think that's what this seeks to address.
I have a question. If you're does this get to if you're charging by the page, you reduce or increase the number of lines per page so that your transcript ends up being thicker than it would otherwise, depending on your font choice or size of printing within your word processor or whatever you use to create the transcript. I don't know that we have particular standards on how you do that, and you would, if you're going to adopt S, I don't know how you enforce that, because it's not sending a clear rule so that you know what you're violating or not violating, to where we could judge whether there is a violation of S.
That's an extremely good point. Now, the board does have recommended transcript guidelines, but they're only recommendations, and they don't have the rule of law. I suppose if there's not an underlying rule that says the transcript has to meet these standards, then we don't have a standard by which to compare it. So I agree with that.
Ken,
Yes.
you know, I don't, as I mentioned earlier, I've reviewed the minutes from the June 2015 meeting. I don't find any of these mentioned anywhere in there. And, you know, they're, as written, they don't work, and they raise, as we're discussing, a lot of issues that I think just need to be addressed at a later time. I don't think they're appropriate to be included in the revisions that we're considering at this rulemaking hearing. They may provide a basis for something, you know, some changes that we may consider in the future, but I think it's a bit much at this juncture.
Like then Britain to just table these suggestions.
There's nothing that keeps us from looking at them later, but I mean, we could sit here and talk about these things all day.
That's true.
And we're never going to agree, because there's a lot of changes that need to be made in them anyways, just
Okay.
with the way that they're written.
Mr. Collins, if I'm understanding you, are you suggesting that we do not include any of these subparts? And I'm asking because I need to know exactly what the board's response to this comment is. These rules, according to you, were not presented in June of 2015, and at this point, the board is choosing to not include them as a part of the proposed rule changes.
I'm recommending that we not include them in the proposed rule changes. I've reviewed the minutes from the June 2015 meeting, and they don't reflect that the board accepted these or approved these. We only speak through our minutes, so I don't have any evidence that we did approve these.
Okay. And I guess as a board, are you all okay with that?
I'll second the motion.
We're just going to table these for the time being, and if they need to be brought up later, they shall be.
It's tabling it the proper way to address those.
Well, we're just not going to consider them now for the rulemaking hearing.
And those are two different decisions. I guess tabling would be, we'll bring them up at a later time. You can vote to not include them in the rules, and we can move on. And if they need to be proposed again, we would start a new proposed rule change. We'd start that separate from this, and these would continue on and hopefully get passed and filed with the Secretary of State. And if we need to file new rules, we would do it at that time.
But do you want to make a motion that we not include these in the rules at this time?
So moved, Ken.
And Judge Rambo, do you want to second that
I
motion?
will.
Any discussion? All in favor, say aye.
Aye.
Now, we have to do it individually. Ken Mansfield, aye.
John Rambo, yes.
Ken Gibson, yes.
Britton Collins, aye.
It's failed.
The next comment is that section 0455-01-05. The question is that section and all subsections 1, 2, and 3 still part of the rules? Again, my answer to that would be yes, they are still part of the rules. Section 0455-01-06. Again, the question is, are sections 06-.02, .03, and .04 still part of the rules? Again, the answer to that part is yes. Additionally, this person asked, because NCRA and NVRA approved these types of credits, being the continuing education credits, the board added and approved the following for continuing education credits to section 0455-06-.02. It was added because not all reporters belong to either NCRA or NVRA. This is listed as subpart 4, professional service experience of a maximum of 1 CE credit, 10 hours, may be earned for professional services on the following basis. A, service to a national or state association board of directors for 1 year, 1 CE credit being 10 hours. B, chairing and serving on a committee verified by the chair of the committee for 1 year, 0.2 CE credits, 2 hours. C is proctoring a national certification test, 0.4 CE credits, 4 hours. D, monitoring a national certification test, 0.2 CE credits, being 2 hours. E, mentoring or interning novice reporters and or students for a minimum of 4 months, 0.2 CE, being 2 hours. F is outreach and activities such as speaking at a career day type event, conducting tours of courthouse or other workplace, hosting a student or novice at a workplace for a day, speaking to court reporting students about one's work or other like activities, 0.1 CE credits. And G says completing and obtaining any portion of a state or national certification proficiency test, 0.2 CE credits, being 2 hours. I guess the board will need to discuss whether or not to adopt that as part of the continuing education.
Always been my understanding that if a state association approves CEs, if a national association approves CEs, the Tennessee Board of Court Reporting automatically accepts those. That's the way it's always been, and that's what the rules are. These really mirror what the states and the national associations already allow. So, do we need to put this language in, or is it already understood? That's their discussion.
I think it would be helpful to put it in if it's the same as, it just gives you another place for court reporters to look and find it.
Listening to you, Mr. Chairman, it seems as though, if I'm understanding you correctly, you said if a state or national certification, I guess, association accepts a certain CE credits, the Tennessee Board of Court Reporting will also accept that.
That's correct.
I think that there may be a simpler way to include that as part of the rules rather than detailing as this particular question states. I think we can almost state what you've said as far as the Tennessee Board of Court Reporting accepting national and/or state certified continuing education credits. Something as simple as that, but I'll leave that for the board to decide.
Or any
We are-
approved CE.
I'm sorry, but that's already in the rules.
In the new proposed rules, Britton?
Well, no, I mean, if you look at 0455-01-06-.02, subpart 1A, says continuing education hours may be earned from verified attendance at or participation in a program, activity, or course through a national or state court reporting association.
Okay, so in that case, the response would be that that is already covered by the currently enacted rules.
Right. I think these rules possibly are going to the fact that not all members, not all reporters are members of a national or a state association.
And that is what this question stated. It said it was added because not all reporters belong to either NCRA or NVRA.
Right.
Okay, but then we have here as subpart 1B, verified attendance presented by a continuing education sponsor in subpart .03, and if you go over there, it finds a whole bunch of people who are sponsors: the National Court Reporters Association, the National Verbatim Reporters Association, TCRA, a computer user group whose programs or courses have been approved, a city, county, state, or federal judicial body, a university or college course, a school, college, university, state agency, or other association approved by the board. I don't think we ought to be giving people CE credits for giving courthouse tours. I mean, they need to be going to courses and learning things.
I tend to agree with that.
And we have a laundry list of entities through whom they can go and take those courses that are already in the rules now. So I don't know why we need to add 8 more subparts.
I think the simpler we can make it and the more brief we can make it, the better off, as long as it concerns everything that we need for it to include.
I agree 100%.
Thoughts?
I kind of had a question on it. It seemed like kind of strange to me that the NCRA and NVRA is talking about not belonging to it. How did in the first part, how could you not belong to it and then serve on their board of directors or chair their committees?
Well, you could.
I just thought that was odd. Like, how did you get A and B out of that?
You couldn't.
Or monitoring or proctoring the certification tests. The certification tests are administered by those associations.
That's true.
So
Right? All these things, all we're talking about here is all things that involve these organizations.
And all the other things that you mentioned are how people who are not a member of the association get their CE credits.
But the only things that are left are giving courthouse tours or taking a proficiency test.
Well, if you're a member of the association and you take a proficiency test and pass it, you get CE credits from the National Association, which the Tennessee Board of Court Reporting would honor as well.
Right.
Oh.
Okay. I'm going to move that we not include these suggested additions because I believe that the existing continuing education rules sufficiently encompass all of these activities.
Do you want to phrase that in the form of a motion?
I did. Maybe it didn't come across that way.
Well, do we have a second?
I'll second that motion.
All in favor? Aye.
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 Britton, aye.
Okay, so the next statement in this list of questions is 0455-01-06-.03. It just says continuing education sponsors and programs, no change. I'm not sure if that's anything the board needs to address. There's no question under it.
I don't think so.
Okay. 0455-01-06-.04, activities not qualifying for continuing education credit, redefined. 1B, serving on committees that are not court reporter related activities. And then it says deleted 1C and D. I'm not sure if this is something, again, referring to a prior court reporting meeting. I'm not sure if that's been discussed before.
I don't remember it. But of course, we wouldn't give CE credits for serving on any board or committee that's not related to the profession.
So I guess for a response, is the board okay with me saying the question was not clearly defined, and so the board offers no response?
Correct.
Okay.
Well, I get what it's saying.
Okay.
I think it's clear what the suggestion is, and frankly, I think that the suggestion as to how to rephrase 1B as it says right now, 1B just says serving on committees. The suggestion is that it should be revised to say serving on committees that are not court reporter related activities. I think that is probably an appropriate change.
Problem with that, Britton,
I beg your pardon?
if you serve on a board or a committee with the National Court Reporters Association or a state association, the National Court Reporters Association allows you to have CE credits for that.
I understand that, but there's an internal inconsistency in our rules because we're saying if you serve on we're saying if somebody like the National Court Reporters Association would give you credit for serving on a committee, we'll give you CEs for that, but then over here in .04, we say we don't give credit for serving on committees. So I think that the change just makes sure that we don't have that internal inconsistency by clarifying in .04 that serving on committees that aren't court reporter related is what we're excluding.
But if we left out that language entirely, the language that you do get credits for serving on boards of associations would still stand.
I'm sorry, I didn't follow you there.
If we eliminate the part that doesn't give credits, the part that does give credits still stands. So I wonder if this language needs to be in at all. And I'm just putting that out as a discussion point.
Would it be difficult to determine if a court reporter was given credit for serving on a non-court reporting board, and they were given credit by NCRA? Would it be difficult to determine that you were given credit for something that NCRA allows, but our board does not?
NCRA only allows service on a state board or a governmental regulatory board. That's all. Or of course, their own boards. So they don't allow any credit for a non-court reporting related board service of any kind. I think we could either eliminate the language altogether or do as Britton suggested. Either one would work, I think, adequately.
I agree with you, Ken. It needs to be one or the other. I don't have strong feelings either way.
Ashley, do you have a preference?
I don't have a preference. I think what Britton said. Let me make sure I'm clear. So you're saying that there's already a rule that indicates that you get CE credit for serving on a state board or regulatory authority, and I think this suggestion is that adding the language that are not court reporter related activities would not qualify. I don't think it hurts to clarify that, and then it eliminates all question. So the board could vote to adopt that. That would be fine.
Yeah, I mean, the problem is we have a rule that says that if you participate in an activity that's sponsored by, or basically you participate in an activity that results in CE credits being given to you by a national association, then we will honor those CE credits and accept them for your licensure purposes here in Tennessee. But then over here we have this rule that says it doesn't qualify if it's simply serving on a committee. And so that's the inconsistency. is that they would give you credit for that, but then we're saying we're taking it away over here in section .04. So
And it-
either we just need to delete the language that says serving on committees doesn't get you CE credits, or we need to clarify that if you serve on a committee that is court reporter related, you'll get them, but if it's not court reporting related, you don't. Either one, I think, works exactly the same. So for simplicity's purposes, I think we should just delete it.
And my only other comment as it relates to this particular section is this was not a section that was opened when we first drafted the rule. So this was not a section that was published to the public that would be discussed today. As another option available to the board is that you could table this question, and if we needed to open that section of the rules to look at proposed changes as a whole, we could do that separately and publish that to the public to solicit all comments on that rule completely.
I don't think we need to table it. I think we can actually take action on it today to either delete it or add this language, one or the other. I'm just waiting for a motion for either one.
But Ashley, is
That
that
was published now.
really
I'm sorry, can you repeat that?
I think Ashley's point is we can't address this for a final rule in today's rulemaking hearing because the notice of the rulemaking hearing didn't give notice that we were considering changes to this section.
I understand. So I guess we would have to table it at this juncture.
So that would be my advice.
I move that we table it.
Okay. We have
Second.
a motion and a second. All in favor? Aye.
Chancellor Rambo, aye.
Ben Gibson, aye.
Britton Collins, aye.
The next question is section 0455-01-06-.06, which is noncompliance with continuing education credit. The question is, why was this section deleted? That question is also asked of section 0455-01-06-.06, waiver of CE credits. They want to know why this section was deleted as well. It says this section allows for military service. It also allows for any incapacity, illness documented by a licensed physician should the reporter develop some form of physical problem and cannot obtain their credits to request a waiver. For example, breast cancer and/or chemotherapy treatment.
Guess it goes back to the court reporter law. Does it make a provision for a waiver of CE requirements?
My response to that would be that it does not. Section TCA 20-9-612 indicates that licensed court reporter shall obtain CE credit, and so to waive that, I feel like would go in contravention of currently enacted laws.
I agree. I think that if a person was to face this situation, they could take inactive service and deal with it that way.
Or let their license lapse and re-up it later. I mean, there's a number of options available to them.
True, that's true.
So is the board? I'm sorry. Go ahead.
No, you go ahead, please.
I was going to ask if the board was okay with my answer being that was removed as it exceeded the board's authority pursuant to TCA 20-9-612.
That was my thought also, because I don't think that the law makes any provision for a waiver of CE requirements.
I
I
concur.
agree.
We did have one visitor sign in, I guess Emily Sipe. Did you have any comment on the rules or anything? Okay. Any other questions on the rules?
I have a couple of things, or a few things that I've noted. I'm not sure if anyone cares, but
We care.
and I'm sorry. Let me get my notes up. I apologize if you'll bear with me for just a second.
Britton, are you looking at the red line version?
Yes, and I have some comments with respect to some of the sections that we have not addressed in this rulemaking hearing, but I guess we can save those for later. They're not really that important. So
Again-
yes,
I would just say if we haven't notified the public that we were going to be discussing them, my advice would be to wait until, if we need to do proposed rules or another rulemaking hearing for another time.
okay. All right, then, yeah, I'll address only those things that are in the rules that are subject to the notice of rulemaking hearing, and I'll be referring to the red line version that we received last night or last week or whenever that was sent out. Under section 0455-01-01-.05, that's the section on maintenance and inspection of board records. In subpart 1, accordance should not be capitalized.
Make that
And also-
change?
I beg your pardon?
I can make that change.
Okay, and then in subpart 3, we use in the first sentence we use the term director, but then in the second sentence we use the term executive director.
We can add executive to upon request to the executive director.
Yeah, I don't know which one it is, but it should probably just be the same for both. And I guess to that point, it is now that we're under the Department of Commerce and Insurance, is there actually someone who has the title of Executive Director of the Board of Court Reporting?
Yes.
That would be Nicole Avers.
Okay, but there is, in fact, an Executive Director of the Board of Court Reporting.
There is.
Okay, I just wanted to be sure that person actually exists.
Absolutely.
So, okay. Let's see. Do you want me to reference these as the new section? Some of these section numbers have changed. Do you want me to?
Whichever is easiest for you, I think I'll be able to find it.
Okay. Under the old section 0455-01-03-.06, which is now 0.02.
Okay.
Let's see, and I gotta find that myself here. That's the section on application for licensure standard process. It's denominated as a first paragraph, but there's not a second paragraph.
Okay.
You see what I mean there?
I do. We can remove that subpart 1 reference.
Okay, and then in subpart, what is there, subpart 1B, what currently exists as 1B, board, which is the last word in that subpart, should be capitalized for consistency with other sections.
Okay.
Let's see, in 0455-01-05-.01, that may not be, is that on our list?
I don't believe that's open at this time.
Okay, then we'll ignore that one. In 0455-01-05-.06,
Okay.
that's the new section on the civil penalties.
Yes.
In subpart 1, that first sentence there says, with respect to any licensed court reporter, comma, temporary licensed court reporter, comma, the board may. I think that should say licensed court reporter or temporary licensed court reporter, as opposed to having a comma in between the two. It should just be an or.
Okay.
Okay. And then in 0455-01-06-.01, that's the section on continuing education requirements.
Yes.
After we define continuing education with the CE in subpart 1, do we need to continue to do it that same way each time thereafter? I mean, it seems like we either need to have one or the other. Either have it as defined as CE or just refer to it always as continuing education credit.
I think when Nicole and I were looking at these as far as drafting them, I think we had that discussion, and I think we just wanted to be clear in each section. But if the board feels that it's not necessary, we can make that change. It's a minimal change to make.
Well, I guess this gets to kind of a bigger issue, and this conversation may be slightly outside of the scope of what we're doing, but maybe it's not. But there seems to be a little bit of an inconsistency with how we define in our rules continuing education credits versus the allocable time for continuing education. You know, the hour that somebody gets for actually sitting in the room versus the credits that we allow them for whatever it is, 15 hours of classroom time. And I don't know that I have a great suggestion for how to resolve that right now. But as it relates to this section .01 and then the next section of .02, which I know is not before us, but there does seem to be some inconsistency with how we interchangeably use the terms continuing education and continuing education credit, and I'm not sure it's as consistent as it should be.
If I could add to that, we defined an hour for continuing education purposes as 50 minutes or more. But then you go on in subpart 4, we'll give a half-hour increment credit. We don't define if a half hour is 25 minutes to be consistent with 50 minutes, meaning an hour.
Yeah, and just so I can highlight this point, I know that we're not discussing the next section here today, but if you look at 0455-01-.06-.02, if you look down at like subpart 2, where we talk about courses completed that are part of the curriculum of a university, college, or other institution, and we say 1 semester of coursework is equivalent to 5 hours of CE. Well, we seem in the previous section to say that you need 2 hours of CE credit in order to keep up your licensure. So are we saying that you get 5 CE credits or 5 hours of continuing education to then be allocated to the CE credits? I just don't think that they're clear, because we keep using CE and continuing education when we refer to both of them. I've probably lost everyone.
So are you suggesting that the board at this juncture define continuing education, I guess, under subpart .01 of that section?
I think that there needs to be more clear divide in the terminology between when we say we are giving you continuing education credit for the 2 CE credits that you need in order to renew your license versus the continuing education that we will allow you to gain hours for that then get applied to your CE credits.
Did you have a particular language you would like to use to include there?
Goodness, no. Of course not.
And I'm sorry, I didn't follow on the distinction between the two.
And I'm certain that that's my fault. So what we say in our rules is that in order, what we're saying in this this section 045-01-.06-.01 is that in order to renew your license, you have to complete 2 credits of continuing education, and then we say CE, in the 2-year period before your license expires. And then a continuing education credit is 10 hours of continuing education. So then what we're really saying is you have to have 20 hours of continuing education in the 24 preceding months in order to renew your license.
Right?
Correct.
But then we use these terms of continuing education and continuing education credit interchangeably over the course of the next couple of sections in a way that makes it very confusing about whether we're talking about hours of continuing education or continuing education credits. And so maybe my point is, do we really need to talk about 2 CE credits instead of just saying that you need 20 hours of continuing education?
Credits versus hours.
So
Why do we distinguish between the two? Why don't we just say you got to have 20 hours in the 24 preceding months instead of 2 credits, and a credit is 10 hours?
Yeah, I did think that's strange because it is the math that's, it does sort of, when I first saw that, it sort of blew my mind that you had to do the math to figure out.
Yeah.
These
And then we don't have to talk about credits anymore. We just talk about continuing education hours.
Right.
all of these boards that you can go to and organizations to get your continuing education, do they measure by hours or credits?
Yes.
I think that was an either-or question.
What happens? What happens is for every hour, which has to be at least 50 minutes, you get 0.1 CE credits. It's the same thing. 1 hour, you have to have 2 credits, I think, according to the law. 2 credits is 20 hours. But each hour gets you 0.1.
Why not just simplify it and say 20 hours and leave it at that? Because everybody knows math is hard. And
I think the schools could do it. I really think they
Yeah,
could
but-
go back to hours.
Does the law, though, say, the TCA, does it say 2 credits? That may be the problem.
I will look that up. It says,
Brad, you're right.
in order to maintain licensure, all licensed court reporters and holders of a non-resident certificate will be required to obtain a minimum of 2 continuing education credits over a 2-year period. in
And I
courses.
think that's where the issue comes in. I think
Set up
it's
that
kind of clarified the way it is now. It's obtuse, I agree. But you have to understand that each hour is .1, and the law says 2 credits, which is 20 hours. But I think we may have to leave it like it is.
We should just move along.
You're right.
Okay.
I do think we would be better off if we choose one method or the other under .01, that continuing education credit, that you capitalize C, E, and C, or you don't, and put, I think it makes more sense to have it as capitalized continuing education credit and capitalize continuing education hour and make it consistent throughout that section.
Of course, then if you go to some of the national organizations, they give CEUs. So if we just leave it as continuing education, I think that'll take care of it altogether.
Clear as mud. So we've decided to, has the board decided to leave it, or are we capitalizing continuing education credit?
I think that the way the language is now, it's more a point of clarification, even though it is somewhat obtuse and confusing, but I think it could get possibly even more confusing if we did anything else to it. So I,
Have all those CEs in there, that, to me, that makes it more confusing.
So maybe take the parenthetical out of subparts 3 and 4 and just have continuing education credit just as language in the rule.
well, it has to say continuing education hour. It has to continue to say that.
Right. And the only thing I'm suggesting that we remove is the parenthetical with the CE in it. So it would still say continuing education credit means 10 hours of continuing education. It just would not have the CE there.
Brackets.
We can
And-
certainly do that without any problem.
And under
Yeah, but-
subpart 5, lowercase the r in requirements.
And non-resident licensees doesn't need to be capitalized either, but.
Oh, neither does renewal period if we go that far. And 2.
Yeah,
But we're straining at gnats, I think.
and to the point about the renewal periods, does subpart 1 here not need to say beginning with the first renewal period and every renewal period thereafter? As opposed to beginning with the first renewal and every renewal thereafter? Otherwise, I don't understand why we describe what a renewal period is, because it's not used anywhere else.
I can add that to subpart 1. So I'm
Does that
clear.
make sense?
It did. So I'm clear. I'm adding renewal period to subpart 1. I'm removing the parenthetical in subpart 1, changing the capitalization of subpart 2, removing the parenthetical in subpart 3 and 4, changing the capitalization of subpart 5, and removing those parentheticals in subpart 5 and 6 as well. Is that correct?
Correct.
There's a typo in number 2 on 24 also.
We'll add that hyphen to 24.
You know, but I love everything we just did, but now we have a problem in the next section, which I know is not in front of the rulemaking hearing right now, but we use CE in that next section.
So, in the alternative, what we could do is leave it and then propose it as a new change after these have gone forward. And then make that complete change to the entire CE section.
How,
Whatever's the most efficient means of doing it, I think.
how often can we do these changes? I mean, can we do them anytime we want as long as we just start the process up?
Yes, sir.
So there's nothing that would say once these go in, we can't just immediately turn around and then start looking at some of these other issues?
That's correct. What we can do is, if once these go forward, once the board is okay with the changes, and at the conclusion of the hearing, I can draft. I can look at the continuing education section and begin drafting that, and then at the next board meeting, present that to the board, and we can begin the process on that. And because these are minor typo changes, I don't think we've talked anything substantive as far as this. We probably could do those as proposed rules rather than through a rulemaking hearing.
Okay. I just assume that because I don't know that if we only fix section .01 as it relates to this distinction between continuing education hours and continuing education credits, we don't really do any good because section .02 is still screwed up. So I think we ought to just handle them both at the same time, as Ashley's suggesting. Make the other changes that we've talked about here, of course, with some of the typos and adding a few words here and there. But I'd say that we just leave the issue of the distinction between continuing education credits and continuing education hours for another day and see if we can't come up with just a better global fix for that issue.
I think if we just try to mirror what the TCA says, that'll take care of that problem. And I think that's what we have now is an issue.
I'm okay.
Fix it later.
Okay, I will. I'll make the small typographical changes, and then we will address the continuing education credit and hour at a later time.
Is there anything else to discuss? Are we ready to make a motion on the rules?
That's all I had.
I have one question. I don't know if it's appropriate right now, but is it in order to see? I feel like we should be able to roll over hours if you get too many in one. Can you make a change by rule on that, or how would you accomplish that?
The statute doesn't allow for a rollover
Okay.
from period to period. So
Okay.
you have to lobby the legislature to change.
Okay, thank you.
Legislative change.
Well, here's a point of distinction maybe on that. If we're going to mirror what the National Association does, they are now allowing rollover of credits. And if we're going to give credit for that, in effect, we are already doing that. Although the statute doesn't say it.
Well, but and maybe I don't understand our process the way that I should, but I mean, isn't somebody's going to a course and they're getting some sort of certificate or something that shows that they went to this 1 hour course, and then they're submitting that to the board and saying, I want credit for that.
They are, but they can also send, for example, the National Court Reporters Association transcript to the board and highlight the applicable period of time which they've obtained credits also for CE credits. But what I'm saying is, well, I'm really not saying anything.
No, I understand what your point is.
Because if they allow rollover credits, it wouldn't show on the current term anyway, so it's kind of a moot point. A person has to look and see when the CEUs were granted and to know if it's in the applicable time or not.
Yeah.
So whether they roll over or not is a moot point because the law doesn't allow it. Anything else? I make a motion we adopt the rules.
Second. I second.
We have a motion and a second. All in favor? Aye.
This is John Rambo, voting yes.
Ken Gibson, aye.
Britton Collins, aye.
And I'll just state, for the record, the economic impact statement and regulatory flexibility analysis was adopted at the last at the last board meeting on November 20th, 2015. I guess my only other question for the board is, did you want to leave this open for any other comments, or do we want to close it and I will move on to begin the edits and sending it to the Attorney General?
I don't think we made any substantive changes by virtue of the comments today, did we?
No, sir, we did not.
I make a motion that we adopt them as they are and move forward.
Well, with the changes that we've
Correct.
approved today for Ashley to make.
That's correct.
Second.
All in favor? Aye.
Aye.
Ken Gibson, aye.
Britton Collins, aye.
That will conclude the rulemaking hearing. I'll turn it back over to you, Nicole. Or the chair, sorry.
Business.
New business.
If I could, I would just ask a question for point of clarification. When is the anticipated date that the court reporters will be able to renew their license online and be able to view their up-to-date CE credits? And also be able to use the state system whereby we can check a license and renew and all those things.
Well, we were hoping to have that done for this renewal cycle, but unfortunately, the contract was not in place to do it. So we've unfortunately been pushed back until December to get the licensing system in place. And so it'll be next renewal cycle before everyone will be able to renew online. You will be in the licensing system sometime around Christmas, but it'll be next year before you guys will have the full benefits of being able to renew online digitally and all of that fancy stuff.
I know it takes time. It'll be great when it's in system and it's in
Yeah.
place. We'll love it.
People will be able to upload and get and change their address and all of that stuff, by the new year. But the real noticeable thing will be when the renewal comes up next time.
And so by the next renewal cycle, will we be able to use a debit or credit card or electronic check for?
Yes.
Great. Great. Any other new business?
Per our rules and regulations, we're required to elect officers at the first meeting of the calendar year.
I thought we had decided to go to fiscal year because
Yeah,
of
but
the
I'm-
problems that it causes.
I'm just telling you what the rules say.
Well, we already passed that.
Well, actually, we're not. This is the first meeting we've had in this calendar year.
Thought we had one in earlier. Did we not?
That was in November.
Okay.
of
Last one
last
was in
year.
November.
All right. Then let's do it.
Okay, are there any nominations for the floor for chair?
Ken, how long is this your first or your second term as?
This is, on this particular go-round, this is my first year as chair, but I was chairman 2 years before.
Right. Well, you can't do 2 consecutive years in the same office. So
That's correct.
I just wanted to see.
I had a year out with no office position.
Yeah. Okay. I'll nominate Ken for chairman.
Second.
Could you clarify the record there, Ken Mansfield?
Oh gosh. Yeah.
Got
Sorry,
to
I
Ken.
guess I didn't realize.
Th-
That
th-
didn't occur to me.
Yeah.
That's okay.
We have
Yeah,
Kenny
sorry,
G
yeah.
now.
Yes. Ken Mansfield for chair.
We have a motion and a second. All in favor?
Mr. Britton, aye.
Chancellor Rambo votes yes.
Ken Gibson, yes.
I abstain. It still carries. Well, I guess I'll vote aye. I nominate Britton Collins as vice chairman.
I'll second.
All in favor? Aye.
Aye.
Ken Gibson, aye.
I'll vote aye.
Now, I think that Earl has served 2 years as secretary, so him not being present today, we can't nominate him again.
Correct.
So we have the position open for secretary.
You actually don't have to have a secretary anymore.
We don't.
You do not.
Okay.
We take the minutes for you. You don't have to do that anymore.
I knew that was the case, but I didn't know if we still had to specifically fill that office.
You don't.
Can I ask a question related to Secretary? It seems to me it'd be more efficient, since we have to do roll call votes, that someone actually call the roll, so we don't have to say our name, and there's some order to it instead of, well,
In most of my boards, they ask that I do it, and
I would suggest that, Mr. Chairman, for this board.
I absolutely agree. I think that would be appropriate to have our executive director call the roll.
that would be fine. I'm glad to do it for you.
All right, that's great. I don't think we have to vote on that. I think that's just a matter of administration.
I'll be glad to do that for you.
If I can address the board, actually, TCA 20-9-604, subpart F does read, at its first meeting each calendar year, the board shall elect a chair, vice chair, and secretary from its membership.
Oh, it does.
It does.
That's what I
Yeah,
thought.
Our rules and regs say the same thing.
That's what I thought too. I thought it was in the law.
I am correct.
So we'll have to have a
Sorry.
secretary. I nominate Ken Gibson as secretary.
I'll second it.
Have a motion and a second. Our executive director will call the roll.
Ken Mansfield,
Yes.
Britton Collins,
Aye.
John Rambo,
Yes.
Ken Gibson.
Abstain.
Unwilling. Oh no.
No, I'm willing.
That's the easiest one. You don't have to do anything.
Well, I like it.
All right. Motion carries.
Any other new business?
No, sir.
Upon hearing no other new business, do we want to set the next date?
Next date is set for August 19th, 2016,
At 9 a.m.
9 a.m.
So the next meeting date is August 19th at 9 a.m. here at the Davy Crockett Tower. Hearing no other business, I'll entertain a motion for adjournment.
So moved.
Second.
Second.
Roll. On an
Our
adjournment.
executive director call the roll.
Ken Mansfield,
Aye.
Britton Collins,
Aye.
John Rambo,
Aye.
Ken Gibson.
Aye.
Motion is
Mr.
adjourned. It is now 20 minutes to 11 a.m.
For everyone's information, the meetings are posted on the website under public meetings. It's on the left side of the screen on the website.